Good afternoon and welcome everyone to the Mediation Advocacy webinar organized by Center for Conflict Resolution of Pravin Gandhi College of Law. I would take this opportunity to introduce our college and our committee. Marcel Proust once said, "The voyage of discovery is not in seeking new landscapes, but in having new eyes." This observation clearly enunciates the goals and objectives of SVKM's Pravin Gandhi College of Law. PGCL was established in 2004 and takes a holistic view of education and focuses on both academic as well as personal development of the students. It aims at fostering innovative practices towards legal education and legal processes in order to make law an efficient instrument of social development. The qualified and experienced faculty at college ensures that the student receive the best education and skills. PGCL recognizes the spark of creativity in its every student, and they are provided with immense opportunities to prepare them for the legal world. I would also like to say a few words about our committee, the Center for Conflict Resolution. One of the important functions of law is to ensure justice and resolve conflicts between the parties. Understanding of the dispute resolution mechanisms is hence very important for every legal professional. Adversarial and alternative dispute resolution both are imperative for any lawyer to hone their skills at. The Center for Conflict Resolution at Pravin Gandhi College of Law was established in 2020. The center aims at conducting training, research, and discussions on alternative dispute resolution methods. Thank you so much. Now I'd like to pass on to Vidisha. Over to you.
Thank you. Good evening, everyone. I take great pleasure to introduce our esteemed guest, Dr. Bharti Rao. Ma'am is a professor with a passion to spread mediation among students in India. After 18 years as a bank officer, she switched to academics. She worked as a psychologist counselor in business school for 6 years, and since 2015, she has been a visiting faculty at Alliance University in Bangalore. She has masters in psychology, doctorate in management, and PhD in counseling. Bharti ma'am is one of the first from India to train in mediation at Singapore Mediation Center in 2015, and she is on the panel of Singapore International Mediation Institute from 2018. Her aim is to spread the concept of mediation among all students and people in India. To this effect, she has submitted a proposal for a basic course for creating awareness of mediation to the Supreme Court Mediation Committee. She participates regularly as a judge in mediation competitions for students both at national level and international level. Thank you for joining us today, ma'am. Without further ado, I would like to hand over the mic to Bharti ma'am and commence the session.
Oh, thank you so much for the wonderful introduction, both about the college and about me. I hope I stand up to your expectations and to the introduction. Now, first thing is I would like to thank your college, the Pravin Gandhi College, for giving me this wonderful opportunity to speak today. And more importantly, as a teacher, I would like to thank each one of you for making time to be here in this talk. I know how students feel about attending classes and attending talks, so that is why an extra thank you to all my students here and of course others. Now, coming to the topic of today, that is mediation advocacy in the era of Singapore Convention on Mediation. This is a hot topic in the perspective of mediation and amongst mediators these days. This is because of the Singapore Convention on Mediation, which was put in place in August of 2019, and it came into enforcement in September of 2020. Now, this is a historic milestone and a treaty in the history of both alternate dispute resolution as well as in mediation. After the Pound Conference, in which the concept of mediation was first introduced by Professor Sanders in Minnesota in United States, this is the next most important landmark in the history of mediation. Now, why is it that the Singapore Convention is so important? This is because for the first time in this convention, equal stature was given to mediation as an alternate dispute resolution and also a new instrument called the International Mediated Settlement Agreement was introduced in this convention. Now, this instrument has got unparalleled power both in mediation as well as in alternate dispute resolution. So we'll be talking about this instrument at a later point in today's talk. Now, another thing about this convention is the purview of this convention is restricted to cross-border disputes and to international law alone. Why then are we giving so much of importance to this convention? So, the reason for this is just as the Singapore Convention has given legitimacy and recognition to mediation in the field of international law and cross-border disputes. Similarly, it is an expectation and hope that in time mediation will be very much accepted and recognized in the field of domestic disputes also. Now, this Singapore Convention is called the United Nations Convention on Settlement Agreements reached through mediation, and since this is signed in Singapore, it is called the Singapore Convention on Mediation informally. Now, it's not as if mediation is a new area in India. We had our own forms of mediation, like for instance, we had the Panchayat Raj system, and even now we have the Panchayat Raj system. We also have the Lok Adalat, which is an accepted and recognized form of self-government in India, across in India. However, what has happened is, in the last couple of decades, because of opening up of the economy, there is globalization, then there is liberalization and urbanization, big words. All of this has resulted in changes in society. Like for instance, earlier we had many more of joint families. Now they are almost non-existent. Then we have more women going out to work and such other social changes. Because of all this, what has happened is there are new variations to the old conflicts, and this requires a new method wherein these conflicts or problems can be solved. Mediation answers this requirement for resolution of conflicts in a new way. Now, do we have awareness of mediation in India in the current form? No. The awareness of mediation is not much more in India, although in the last couple of years it has increased substantially, and there is a lot more of curiosity about mediation when people hear about it. Therefore, it is in the interest of mediation to have mediation advocacy through conversations and communications on mediation related topics and mediation amongst the students, the people, the lawyers, businessmen, everywhere, wherever possible. Now, just imagine we have a small sapling that is planted. In the beginning, we have to take the sapling has to be taken care of. It has to be watered, then it has to be protected against the sunshine. We also see sometimes the bark of the banana tree, the hollow part of it is placed against the sapling to protect it. Then what happens? The sapling, it gathers roots, and then after a time branches come up. After a while it gives fruits and flowers, and in a while it is also possible it will grow into a tree, and then it gives us shade. Similarly, mediation as a method for resolving problems has to be nurtured through mediation advocacy. For this, it is essential for all mediators and the would-be mediators of tomorrow, that is all of you, to have a basic information module wherein within 2 minutes flat we should be able to tell anyone who asks us what mediation is. We should be able to tell them the intricacies and benefits of mediation. People do not have the time to attend webinars, lectures, and so on. So in those 3-4 minutes, we should be able to impress people and attract their attention. Simple examples, like for instance, how a dispute amongst neighbors, the issues on how the water is to be divided amongst them, or it can be a landlord-tenant dispute, it can be insurance-based dispute, or even package tourism disputes wherein the terms are not honored. All of these can be examples of how mediation can assist in resolving these disputes. Now again, we also need to have a basic knowledge and information of the Singapore Convention on Mediation so that we can get across to people. In all this, what we are doing is, through mediation advocacy, we are marketing our product as well as our services as mediators. Now this mediation advocacy is both a win-win for the mediators as it opens up opportunities for mediators, and it is also good for the people, the users, as it is a convenient method for resolving problems, and it also brings about peace and wellness in society. So this is the backdrop with which we will be starting the talk of today on mediation advocacy in the era of the Singapore Convention. I'll be giving a brief introduction. to the Singapore Convention. The nitty-gritties and intricacies you will have to go through on your own at a later point in time. So let's see what is the format of today's talk. Why is it now coming to the Singapore Convention? Why was it that there was a need felt for a convention like the Singapore Convention on Mediation, given that we already had other forms of alternate dispute resolution? This is because there was a felt and expressed need for mediation. In the context of the Singapore Convention, there was a study that was done by the Singapore International Dispute Resolution Academy, SIDRA, wherein 304 respondents across the world were interview surveyed, and they were asked what is it that they were looking for at the time of choosing a particular ADR method. The respondents stated that they were looking for an expedited enforcement mechanism. Now, no other method other than mediation provides for expedited enforcement. So this is the strength and strong point of mediation. And in the context of cross-border disputes, because the Singapore Convention deals with cross-border disputes, the parties stated that they expected greater compliance in the case of settlement by mediation. In case there was no settlement reached through mediation, the parties were willing to take a risk by going through the mediation process. Another risk the parties were willing to take was willingness in case of not reaching a settlement. So there are two things. They are willing to take the risk even in case settlement is not reached. They are also willing to take a risk if settlement is reached and there is no compliance of the settlement agreement. At the same time, they expected compliance in case of settlement of mediation. Another study was in the Convention on Shaping of Dispute Resolution for the Future, which was in the year 2014, wherein 150 delegates from 25 countries met up in London, along with their business councils who knew about their company business. Now, on being asked, the respondents or delegates stated that they were looking for a different way of resolving their disputes or conflicts. 2/3 of the respondents stated that they wanted a cooling off period before a full-fledged arbitration, and they were also looking for a method in which there was more control vested in the parties. Here, I'm pointing here, autonomy vested in the parties. And they were also looking for a method which allowed for quality in outcomes and which assisted them in building of relationships, given that in the business scenario, long-term building of relationships was important. Now, all of these features are included in mediation, in that through mediation resolution, the parties get to have control over the process and how the settlement is reached. There is an effort to have quality of outcomes and building of relationships in mediation. So, parties have shown a preference for mediation. It's not as if Singapore Convention was the first convention in the field of alternate dispute resolution. First, we had the New York Convention in 1958, in which for the first time arbitration was given recognition and legitimacy in the field of alternate dispute resolution, and the arbitral awards were considered as legally binding. Then we had the United Nations Convention on International Trade Law, which was put in place in 1966, which called for harmonization and unification. Now, harmonization is an effort to ensure that different legal systems generate transactions with similar effects across jurisdictions. Simply put, what it means is you have similar laws across different countries. Now, in the case of unification, they went one step further. What they did was there was adoption of the same laws in different legal systems or different countries. Then we had the Singapore Convention on Mediation. What was the need for so many conventions, and what was the reason for the conduct of these conventions? The aim of these conventions was to increase communication and interaction amongst the peoples of the world, to increase world trade, and also to facilitate the voices of people from developing countries to be heard. For this, laws were framed and also implemented to assist the developing countries so that their voices heard. All of this, the aim was that there should be more peace in the world. Now, the scope of the Singapore Convention, as already mentioned, is only cross-border disputes and international law. It does not cover domestic disputes, like for instance, family disputes, inheritance or family law. It doesn't cover employment, consumer dispute, or so on. Then the users can be anyone who is involved in a cross-border dispute. For instance, it can be sole proprietors, it can be businessmen, it can be traditional corporate companies, MNCs, anyone who is involved in a cross-border dispute. Now again, there are specific clauses which define cross-border disputes and what is meant by international in the purview of Singapore Convention. The settlement agreements similarly should not have been recorded as an arbitral award or as a court judgment to be under the purview of the Singapore Convention on Mediation. Now, here are the distinguishing features of the Singapore Convention. I'd like all of you to spend a moment going through these points. I'll be dealing with each of one of them at length in a couple of moments. Yeah, the first one is the international mediated settlement agreement can be in writing and online. Please keep in mind that this convention was put in place in August of 2019, much before the onset of COVID in March of 2020. So the convention conceived of online dispute resolution and put in place a number of statutes and clauses in order to facilitate online dispute resolution. So because of this, online dispute resolution during times of COVID has become that much more easy. This is one of the significant contributions of the Singapore Convention. Now, in the context of Singapore Convention, it is required that the settlement should be reached through mediation and evidence has to be provided for this. The word clause in writing has special significance in the purview of Singapore Convention in that it includes all forms of electronic communication, that is SMS text, emails and so on, wherein the information can be recorded electronically and it can be retrieved at a later point in time or whenever required. It's not required that the entire process of mediation be completed at one go or that it should be in a single document. It can be done in bits and parts. That is ad hoc. Another feature of the in-writing and online is that mediation can be institutionalized in that we have mediation platforms wherein the documents can be attended to then and there without waiting for SMS replies or replies on email. Skype and Zoom or AnyDesk are also used in dispute resolution. Now, coming to the mediation platforms, they have their own set of rules and the mediators can be both in-house or they can be taken from outside. We have one such institutionalized mediation platform on the Singapore Mediation Center. This is the most important statute which every one of us needs to know as a mediator and as a would-be mediator. This is that the International Mediated Settlement Agreement is enforceable, predictable, and it gives certainty to the process of mediation and the settlement agreement. We do not have any other method of dispute resolution that assures enforceability of the settlement agreement or the resolution. So this is the chief strength of the Singapore Convention. Now, what do the signatory countries have to do in order to ensure enforcement? They have to change the laws on recognition and enforcement, and they also expand the number and nature of legal instruments. That is the extent to which changes are made in order to ensure enforcement. Now, the signatory countries also modify their own laws and rules of civil or court procedure for the purpose. So, it's a very important statute. The next is, how is it that this enforcement statute affects the two disputing parties? Through the International Mediated Settlement Agreement, both the parties get to use the agreement as a sword against a sword, in that if one of the parties does not honor its end of the bargain, the other party can attach or seize the assets of the dishonoring party to the extent that dishonor has occurred. So in this way, there is an assurance that enforcement of the legal settlement agreement reached through mediation occurs. Of course, there are a number of conditions, cultures, and the nitty-gritties of how the enforcement is done. For this, one has to go through the Singapore Convention in detail. One of the clauses is that the IMSA has to be registered, the settlement in the country where enforcement is sought. Now, mediation also allows for flexibility even in the Singapore Convention as per the Singapore Convention on Mediation. What is meant by flexibility is, it is not essential that only the issues that have triggered the conflict or the fight be discussed on the table of mediation while mediating on the dispute. Issues which may seem unrelated to the triggering issue can also be can also be discussed on the table of mediation. Here I am discussing and talking about an example that was shared in my training session about an Asian family wherein there was a fight amongst an elderly brother and a much younger brother in his 20s, and the brother almost into his 40s. The fight was on the property that was left by the father on his death. Now what happened was, after a while, the mediator went into caucus. Caucus is when the mediator speaks to the parties in confidence and in private, away from the other disputing party. In the caucus, the disputing party can share with the mediator issues which may have impact on the dispute, which he may not have shared in the presence of the other disputing party. Now, in the caucus, this younger brother, when asked, he stated that it was not the property for which he was fighting. He was feeling unloved and uncared by his elder brother, given that it was his elder brother who had taken care of him all along since childhood, because his mother had passed away at a young age. Now, on speaking to the elder brother, it turned out that the elder brother also similarly stated that it was not the property which was the point of dispute or conflict. The elder brother stated that he had loved his younger brother so much and taken care of him since he was almost a child, and he felt disrespected that there was a dispute on property. Now, once this came to the fore, both the parties were facilitated in meeting one another. And what happened was the elder brother gave a tight slap to the younger brother on meeting him, and then both the brothers, they hugged one another and they cried for a while. After this, the dispute was resolved then and there, and the process was closed. Why I've shared this example is about flexibility and issues that are not related, that may seem not directly to be related with the conflict, can also be discussed under the purview of mediation and in the Singapore Convention on Mediation. In this context, the assistance of counseling can be taken for emotional ventilation, and it has been found that about 30 to 40% of the dispute gets resolved in case it has started because of emotional overtones. Now, here again, there was another study that was conducted by the PricewaterhouseCoopers, in which the parties stated that they had come to a resolution and a settlement agreement much before the arbitral award was pronounced. So, if a method like mediation is chosen by the parties, the settlement agreement can be reached much faster and the dispute resolution can be closed, as it is the parties who decide on when to close the dispute resolution process in mediation. So this study, the PricewaterhouseCoopers study, also shows the significance of mediation and the Singapore Convention on Mediation. Now, as to the pathways in which mediation can be entered under the purview of the Singapore Convention on Mediation, the mediation process can be entered through court information sessions, voluntary and mandatory referrals by courts. It can be through referrals by other competent authorities, like for instance, the European Directive. It periodically refers parties to mediation. And then there are legislations to encourage mediation, and we also have cost sanctions to encourage mediation. It is expected and hoped that some of these provisions, or if not all, will be introduced once the Mediation Act is introduced and passed in India. Now the last part is the delocalization, which is the punch of mediation. In that, in delocalization, what is meant is, it is not essential that the implementation or enforcement of the settlement agreement be done at a place where the settlement agreement has been concluded. Now, as to the place in which the process is conducted and the settlement agreement is reached. When the SEM was put in place, the concept of online dispute resolution was non-existent in August of 2019. Therefore, this concept of delocalized dispute resolution was immensely significant, and it was a major contribution in the field of mediation. These are all put here together. It does not require to comply with domestic law requirements of the originating state, and the parties can design their solutions and they are not restricted or specified to a legal system.